I'm the Senior Director of Maintenance, Enforcement, and Locate Services, or otherwise known as MELS. And I'll be speaking to you today along with Christian Lett, who is the Program Manager of the Child Support Recalculation Service. And that's what we're here to talk to you about today. Look at that, it's working well. So what do? We recalculate child support that has been established in either an order or an agreement. It's an administrative service, and it assists parents so that they do not have to return to court or possibly go to court for the first time to update their child support amount to deal with any fluctuations in income or their circumstances. And where are we from? We are in the Ministry of the Attorney General. We are, as I said, part of Maintenance, Enforcement, and Locate Services. We're also responsible there for two other programs, and that is Locate Services, which we'll briefly reference as well, and the Interjurisdictional Support Services. Oh, the whole thing here? I think that's as close as it's going to get. I can hold it though. That's better. So if you happen to have any questions on any of those other programs, we're happy to answer those as well. So recalculation is not new in BC. There has been a program that's been around since 2006, but it operated only out of for orders or agreements that were filed in the Kelowna Provincial Court. But in the spring here of 2022, we expanded the program, and it is now province-wide, and it's available for any orders or agreements that are filed in the provincial court in BC. We've made some changes to the program as well. Previously, it was mandatory for all orders that had been filed in Kelowna. They would automatically be enrolled in the program as long as they met the other criteria. And for agreements, parties could agree to enroll in the program, but it required the consent of both parties. So the new program continues to be an administrative program. You'll probably hear us say that a lot. And it has the benefit still of being a program that's very easy to navigate. It doesn't require a lot of extensive work on the part of the families involved to enroll in the program and then have their child support updated. There's also a couple other changes, though, that we have made. The new program now is no longer a mandatory program for some. So if you are in court, a judge can still make it mandatory for parties to enroll in the program, but is now an opt-in program. And by opt-in is not exactly voluntary. It means it just takes one party to decide to opt into the program, and then the other party is automatically enrolled in the program. So that's quite a significant change for us. It's now also, like I said, province-wide. So those are the two major changes when we expanded the program. So as an administrative program, it's pretty easy to use, but it also comes with some limits as well, and they pertain to the criteria for enrollment. This program is not really meant to serve everyone. Okay? So for those that have much more complicated situations that will require some discretion in order to recalculate their amount, this program may not be for them. We maybe have to, people may enroll and we'll have to look at the criteria. We may have to decline enrollment and they'll have to look to other areas, which may land up being the court. But we have expanded the criteria along with the expansion of the program, and we are able to accept more orders than we were previously. And Christian will talk in a little bit more detail as to what the criteria is to enroll in the program. So I'm now actually going to turn it over to Christian, and he'll go over some of the details of how you enroll and what the process looks like. Put it back in.
All right. Can everyone hear me? Okay, so let's talk about enrolling with the Child Support Recalculation Service. So the process starts with an order or filed agreement. So this would be, in order to recalculate, first an order or agreement needs to be established. Child support needs to be established. And that would be completed before you enroll, and it can be done with the assistance of Family Justice Services. But once the party has an order or an agreement, it would have to be filed specifically with the BC Provincial Court, because at this time we can't recalculate an order agreement in the Supreme Court. And if a party has an agreement that has been made but not filed, it'll just need to be filed before we can recalculate it. The first step would be to go to the CSRS website, which is at childsupportrecalc.gov.bc.ca, and that should be in the general information sheet and also in the slideshow. But so the first step on the website would be to go through the questionnaire. The questionnaire gives some information about eligibility and also just general information about the program, and it can be a way to find out if the program is a good fit for the person who wants to apply. Once they've gone through the questionnaire and found out about the service, if they want to try applying, they would start by applying online by creating a basic BCE ID, or if they have an existing basic BCE ID. They'd complete the online application and submit it, and they would also have to submit a scan of the order or the agreement. They also have an option to fill out a paper application and mail it in if they prefer not to use the online portal, but it just means we can only communicate by phone or by mail in that case. Once the order or agreement and the application is submitted, it would then be reviewed by a recalculation officer who would decide whether or not it's eligible. If there's any missing information, if the order is incomplete, or if we're missing the child support order that we need, we'd request that. And then once it's been reviewed by a recalculation officer, it goes through a secondary check by a manager, who again determines if it's eligible for the service. If it's not eligible, the applicant would be notified through the portal or by mail, depending on how they applied. Just a sneak peek of the questionnaire. It has about 8 questions. Some of the answers are about eligibility, so just basic questions about are they eligible for the service? And some of them have just information about the service. I would always recommend that people start with the questionnaire to see if they're eligible. But if they're not sure or if they're not clear from the answers, always it's good to give the program a call and speak to a recalculation officer who can answer some more detailed questions about eligibility. But this can be good for if there's a sort of straightforward answer for whether or not whether or not they can enroll. At the end of the questionnaire, there's also a link to the PDF form that they can download and fill out and mail in if they don't want to apply through the portal. So once the application has been submitted and once we have a copy of the order and we're looking at eligibility, here are some considerations and 2 main tests for whether or not it's eligible for recalculation. So the first test, do both parties live in BC? At this time, we can only recalculate if both parties live in BC. If either party is out of province, we can't recalculate. Second test being, was the order or agreement made in BC Provincial Court, made or filed in BC Provincial Court? As I said earlier, right now, we can't recalculate orders or agreements in the BC Supreme Court. If an agreement was filed in the Supreme Court, if it can also be filed in Provincial Court, then we would be able to recalculate. But if there's ever been an order made in Supreme Court, then we wouldn't be able to recalculate. Next test was the child support amount based on the child support guidelines table amount. So when child support is established, in order for us to recalculate, it would have to originally have been based on the child support guidelines table amount. If it was any other amount, we won't be able to recalculate. And that might be because of, for example, an undue hardship claim, shared parenting, some shared parenting cases, or just because the parties agreed to an amount that was not based on the child support guideline tables. We also need to be able to determine that the child support was based on the table amount. So we would need their guideline income in the order as well, which brings me to the next part. The next point, which is the order needs to include the essential information under the child support guidelines. So that's under section 13 of the child support guidelines. But mainly what we're looking for are name and date of birth of each child for whom support's to be paid, the income on which child support is based. So usually for just the payer, but in some cases for both parties. And the date on which child support commences and the date of the month on which it's payable. So if yes is the answer to all of these, all of that is included, then move on to the next test. So this section is also relevant because it shows some changes from the previous eligibility criteria. Sandra was talking about how our criteria changed when the program expanded. So as of spring of this year, we can now recalculate in some cases if there's shared or split parenting arrangements, which we couldn't do before. We can recalculate in some cases if there's a child who's over the age of majority, so over 19. And we can recalculate Section 7 expenses. We can also recalculate orders that were made under the Interjurisdictional Support Orders Act, and that includes out of province, so other Canadian orders that were made and then registered in a BC court under the Interjurisdictional Support Orders Act, as long as both parties now live in BC. So situations where we can't recalculate are if income was imputed, unless a very specific situation, if income was imputed because the party is exempt from paying federal or provincial income tax, but the order would need to be clear about that's the reason. We can't recalculate if the order or agreement was based on self-employment income, or if the party then provides income information showing they have self-employment income. We can't recalculate if there is a pattern of income. So if, for example, average of the past 3 years income. If there is a successful undue hardship claim and the order was based on that, we can't recalculate in that situation. Or if the payer stands in place of a parent, so a step parent. Some other eligibility considerations to think about. So these are situations where they may be eligible, but there are additional things to think about. So shared parenting. We can recalculate when there's a shared parenting arrangement, but only if the child support amount was based on the child support guideline amount based on both parents' income. And often there will be an offset amount. So for example, if one parent's table support amount would be $300 and the other's $200, and parent A pays to parent B the offset amount of $100. That would be eligible in most cases. But we can recalculate if certain factors were considered, and this is under a specific section of the FLA regulation. So if the increased cost of shared parenting was considered, or the conditions, means, needs, and other circumstances of the parent, guardian, or child were considered, then we can't recalculate in those situations. So in practice, it basically means we can only recalculate if it's based on the child support guidelines table amount for each parent. And if we are to recalculate for shared parenting, the order agreement has to state the guideline income of both parents. That's the other requirement. We can recalculate for cases where there's children over the age of majority, so over 19, but again, sort of specific circumstances. So one, if an order agreement was made when the child was already over 19, then we can recalculate in that case. However, if an order was made, for example, a few years ago, and in the meantime, a child has turned 19, then we would need the agreement of both parties in order to recalculate. So we would need them to consent to recalculate in that case. And we do that by doing a review either at enrollment or at the beginning of the recalculation cycle after the child turns 19. If there's more than one child and one of them is over 19, then we would ask agreement to either recalculate for all of the children, including the child over 19, or step down and recalculate only for the child or children who are under 19. If the parties can't agree, then we won't be able to recalculate. This isn't a statement on eligibility. We're not saying whether or not the child's eligible to receive support. It's just whether or not we can recalculate. And in all of these scenarios, we can't recalculate if one of the children is over 22 years old. For Section 7 expenses, we can recalculate those, but we only recalculate the proportion of expenses. So the order agreement would have to be clear that the expenses are proportionate, like the division is based on the proportion and based on their income. It would need to, again, have the guideline income of both parents, of both parties. Going forward, we were to calculate only the proportion, so we wouldn't recalculate the dollar amount, but as their income updates over the years when we recalculate, we would change the proportion owed by each party. And the last thing I want to talk about is orders or agreements with complex or complicated terms. So sometimes they're necessary and they're what work best for parents in their situations, but sometimes if they conflict with our own, for example, timelines or our own requirements, it means that we can't recalculate. So one example is orders with very specific timelines for exchanging information and then recalculating support. We may be able to recalculate in those cases, but often we can't stick to the timelines because they conflict with our own legislated timelines. Another example is orders or agreements that have very complicated, or not complicated, very specific terms about how to calculate income based on specific income and deductions. So in a couple of recent files that we've had, we've not been able to recalculate because, for example, there is one that said that if one of the parties' income was below a certain amount, it would be set at a specific amount instead of the actual income. We couldn't recalculate in that case because we can only set the income amount at either the actual income based on tax information or a specific deemed income increase, which I'll get to in a few slides. So in that case, we wouldn't be able to because we can't just set the amount at the amount stated in the order. Another example would be one where the income and deductions, the agreement set a very specific calculation, which would involve us asking for income information that we don't usually have access to. So we wouldn't be able to do the calculation going forward in the way that it was set out in the order. So once we've reviewed for eligibility and decided that the order is eligible, we would proceed with enrollment, which begins with a safety check. The safety check is completed before we reach out to notify the other party, because of course, once one party has enrolled or opted in, then the other party is automatically enrolled, similar to the BC Family Maintenance Agency. On the application, when the applicant applies, they can indicate whether they have safety concerns with respect to the other party. And if they do, then we would reach out to them and do a safety check before we proceed, just so they are connected to resources, so that they're aware of the fact that the recalculation process involves contacting the other party and so on. So once the safety check is complete, we would notify the other party. And before we do that, we would send a request to locate services to confirm the address or to obtain an address if the applicant didn't have one. Locate services is another program that MELS is responsible for. They locate people and at times they can also locate employment and assets. Also, if people are applying to the court and don't know the location of the other party, they can apply through the court registry for a locate services search. The information from the search is kept confidential, but it lets the court application or the CSRS application proceed, even if the party who's applying doesn't have address information for the other party. And the BC Family Maintenance Agency can also do a search or request a search from locate services. It just means that knowing the address of the other party is, it's not knowing the address of the other party isn't a deterrent for accessing court services or the recalculation service. So once we've done a search for the address, or once we have asked locate services to do a search for the address, then the enrollment documents are mailed to the other party. The recalculation officer reaches out to the other party to do an intake call to give them information about the service and also encourage them to sign up for an online account and answer any questions they may have about the service and let them know of their responsibilities in it. And at that point, if a child is over the age of majority, that's when we would do the review and ask for consent of that other party to continue with recalculation. Once that phase is over, we move on to the recalculation process. Before I move on to the next slide, just want to also talk about if either party wants to withdraw from the service. So if the court has ordered the parties to be enrolled in the recalculation service, they would not have the option to withdraw. But if they have opted in and the court order is silent about whether or not they should be in the service, then they can withdraw, but only if both parties agree to withdraw. So one party would have to request it and the other party would have to agree to it. So the recalculation process starts with setting an anniversary date. The anniversary date is the date on which recalculation ends. So everything is, the timelines are all kind of structured around this. Determining what the anniversary date is depends on whether it was a new or older order. So if it's a newer order, so for example, if we had an order made in September of this year, and the recalculation service receives it pretty much right away, we would set the anniversary date 1 year after the date the order was made, the order agreement was made. The idea being to leave a full year between the establishment and the recalculation. However, if we get an order that's older than 7 months, so basically not a brand new order or agreement, we would then set the recalculation, the anniversary date for 5 months after the date of enrollment. The reason for this is it gives time for us to go through the process, request income information, go through the whole cycle that I'll show you in a moment. But it also means that if we had an order that the order date would be more than 5 months, we're not going to wait to recalculate. We're going to do it basically as soon as we can within the timelines. So for example, if we had an order that was made in, let's say, November of 2015, and we received it now, we would not have time to go through the entire process within the month. So then the anniversary date in that case would be set for March of 2023, which would give time for enrollment and then for the full cycle. A couple of things to note, or the main thing to note really, other than the fact that there must be at least 1 year between the date of the order agreement and the recalculation anniversary date. The other thing to note is that recalculation is never retroactive. So we can never go back and recalculate, for example, for that 2015 order, we can't go back and recalculate for the years between 2015 and now. It's only going forward. The recalculation process, in summary on this slide, once parties are enrolled, it happens automatically every year. So you don't have to enroll or sign up every time you want a new recalculation done. The cycle is the same each year, and it ends on the anniversary date and starts about 4 months before that anniversary date. I mentioned 5 months when it's enrolled, and the additional month is to allow time to reach out to the other party, complete the enrollment process, do the locate services search, and things like that. In the first year, the process can be shortened in some cases if complete income information is provided or received up front. So if we have the information we need to recalculate sooner, then we may, in some cases, on a case-to-case basis, be able to shorten that timeline. But for the most part, the timelines are set, and they're set in the legislation in the Family Law Act and the Family Law Act regulation, and can't be changed by the recalculation service. So the process in summary starts with review and notice. So notify parties that the recalculation cycle is about to begin. Also ask if they have any new safety concerns. Followed by the information request. So requesting information from the parties. The parties have 30 days after receiving the request to provide the information to the service. Followed by the statement of recalculation is issued, and it's sent to both parties and also filed with the court. And then there's another 30-day period after receipt where the parties have the opportunity to file in court if they want to dispute the recalculation. After that, the recalculation goes into effect. So when we say asking for income information, it's specific information we're requesting. And it is the tax assessment or notice of assessment from CRA or notice of reassessment, both, I guess, if possible, and the income tax return or the T1 general. These are the two pieces of information we need to recalculate, and it's the only financial information we can base the recalculation on. The reason we ask for both is 1, both are required under the child support guidelines, and 2, we need both verification of the income from CRA, so that's the notice of assessment, and also we need a line-by-line breakdown of the income sources and deductions, which is on the tax return or the T1 general. We ask for this information from any party whose income was a factor in the original order or any party whose income will affect the new child support amount. So in a lot of cases, that's just the paying parent or the payer. But in some cases, that will be both parents. For example, if there is shared parenting, if there is a split parenting arrangement, or if there's special or extraordinary expenses, so Section 7 expenses. Using the income information, the recalculation officer then issues the statement of recalculation, which would include the new guideline income. It would include the new support amount, the new commencement date, and then all the other information needed for the new recalculation. The question, though, is what if somebody is asked for their income information, but they don't provide it? In that case, CSRS would apply a deemed income increase, and the amount of that increase would depend on the number of years it's been since either the court order or agreement was made, or the previous statement of recalculation. So we'd apply the increase to the income in the previous statement of recalculation, or the order or agreement if it's the first year that we're recalculating. And you can see from the chart here that the increases range from 10 to 30%, depending on the number of years it's been since the order agreement or the statement of recalculation. Once the statement of recalculation is issued and sent to the parties and filed with the court, the parties then have 30 days if they want to file a dispute, if they want to disagree with the statement of recalculation. Their avenue for doing that would be to file a court application. So in early resolution registries, that's the notice to resolve a family law matter. They would file that. In all of the registries, it would be an application about a family law matter. If a party if a party decides to file an application, they should notify CSRS when they do so. But if they file an application within that time period, we would then actually suspend the recalculation from coming into effect. So the new amount would not go into effect, and the old amount under the previous recalculation or order agreement would stay in effect while it's suspended. The file stays suspended after we suspend it until one of three things happens. One, a new order is made, in which case it would replace the order we were recalculating. Two, if the application is dismissed or withdrawn, then the statement of recalculation would go into effect on the original date on the statement. Or if 60 days passes without the party who applied taking the necessary steps to move the matter forward, then it would also go into effect on the original date. There are different steps when saying about the necessary steps, depending on whether it's an early resolution registry or another court registry. And the steps are set out in the Family Law Act regulations. And also when we notify the parties that the file has been suspended, there's information about what steps need to be taken to move the application forward. Parties can make a court application at any point during the process. It doesn't have to be during this point, during this dispute period, but this is the only time when we suspend the recalculation from going into effect if they file an application. To communicate with the program, parties have a few options. Probably the best, I would say, is by signing up for the online portal. So if they're going to apply online, then that would create a portal account, which they can log into using their BCE ID. They can send messages to the program. They can upload documents directly to the recalculation officer. They can receive communication notices from CSRS. So when the new statement of recalculation is issued, for example, they would get it through their portal account, the alternative being by mail. They can receive communication notification through the portal, and they can ask questions and send brief messages to the program that way. It's basically a secure alternative to using email, but it's faster than communicating by mail. They can also communicate by phone. We have a toll-free line, and once they're enrolled, they can speak directly to their assigned recalculation officer about their case specifically. And then, of course, the other option would be to communicate by mail. If somebody doesn't want to sign up for the portal, they can still receive their notices by mail. They can mail in any information they need to provide, and then they can call in that case. The phone number and the address are also on the CSRS website. So a few things to keep in mind, one being the limits of an administrative service. So we apply the child support guideline table amount based on income information, specifically tax information from the previous year. But some situations are going to be too complex for us to be able to assist with, like Sandra mentioned. We can also only recalculate based on the terms of the order or agreement that was established. So we can't, for example, change the parenting arrangements or change whether child support is based on shared parenting or not. And we can't determine if a child who's over the age of majority is eligible for support. We can only recalculate if parties agree to do so. Another thing to keep in mind is that we are a separate organization from the BC Family Maintenance Agency. We're separate organizations. We do send a copy of the Statement of Recalculation to the FMA, BC FMA once it's in effect so that they can update their records if the parties have a file with BC FMA, but we are separate offices. Just because something can be recalculated doesn't mean it can be enforced, and vice versa. Another thing to keep in mind when I was talking earlier about timelines, that orders and agreements often will set out a timeline for when parties are supposed to exchange information, when they're supposed to change the child support amount. Often those dates will end sort of middle of the year. Our timelines are based on policy and also on legislation, and will often not be the same as the ones in the orders, or most of the time will not be the same as the ones in the orders or agreement, and sometimes and often can't accommodate the timeline set out in an order. And some other key takeaways. So just good things for people to be aware of if they're wanting to enroll in the service. One is the timeline, especially for the initial recalculation. So the fact that once they enroll, it's going to be 4 to 5 months before the new amount goes into effect. It won't happen right away. In subsequent years, of course, since the cycle starts 4 months early, it'll happen on the same date every year, but it does mean a delay for that first year. As I was saying before, that the dates of recalculation, the anniversary date and the timelines are based on legislation and a policy, and might not necessarily line up with what's in their court order or agreement. And also, I would say for best results, it's good to apply to the program soon after an order agreement is made. That way, you're not risking having to wait 5 months past when the 1-year anniversary rolls around. It'll just be set up and ready to go for the next year. Another thing which I mentioned earlier, but can't stress enough, is that there's no retroactive recalculation through CSRS. So we can only recalculate going forward. If or that several years old is enrolled, we can recalculate that order, but we can't go back and recalculate for those other years. That's a question that we get pretty often, and that's a kind of expectation that some people may have. And then the last thing is just to highlight about financial information. We can only recalculate based on the previous year's tax information. So if someone's circumstances have changed since that tax information was filed, like since their taxes were filed, so if they have new information for this year, we can't recalculate based on that. So we can't project an income for this year or recalculate based on pay stubs or this year, current year financial information rather. So I will hand it back to Sandra at this point.
Okay, we're nearing the end here. You'll notice that we focus a lot on what we can't do. Right? And the reason why we do that is we really feel it's important to manage the expectations, people who are applying for the service. The last thing we want to do is to sort of set people up to think that this service is going to meet everybody's needs, and it's not. It's not a perfect service either, right? Nothing in family usually is. Families are complicated. These type of orders are complicated. And it makes it challenging sort of create a program that can meet all of those needs. We focus a lot on what we can't do, but what we can do is we can remove the need for families to communicate about these issues. And we know that that's often a significant trigger for families, right? It's a lot of stress to talk about the financial issues. So if we can do that for them, we take on the responsibility of tracking it. Once they enroll in the program, they don't have to do anything unless we're asking them to do it, except hopefully file their income tax, right? But hopefully they're doing that anyways. We take that on. They don't have to communicate about it. They can then say, look, to the other party who's complaining because their child support has gone up, I just enrolled in the program. They do the math. We're just following what they're telling us to do. And of course, this is also useful for payers whose income has gone down. And we know from the Family Maintenance Enforcement Program that, when a payer's income has gone down, it doesn't mean that they're going to get back to court or they're going to access the services out there to get a new order. They then have a child support amount that they cannot reasonably pay. But Family Maintenance Enforcement Program doesn't have the authority to make any changes. They have to enforce what's in front of them. And once you have a payer who now is probably developing some arrears, at some point, those arrears get to a point where they give up. And they say, there's no way I'm going to get out from under this. For some people, that might be $10,000. For other people, that might be $70,000, right? And when they give up, they start to give up in other areas of their parenting responsibilities as well. So if we can get people, when they get an order, enroll in the program right away, then we can start to assist them before they're in a situation where their arrears have gotten out of control. It all comes back to, again, though, have they filed their income tax? And that's sort of the one missing link in all of this. And so hopefully, people can get in touch with services that are available to them if they're struggling in that area to get their income tax filed. And as Christian mentioned, we don't go retroactive, but the program was just expanded this year, but you can have an order that's 5 years, 10 years old and still enroll in the program. We won't be going back, but we'll be moving forward. So we can make those changes right now. The deeming income, where a party doesn't provide their information, we have a structure of how much we can increase. We know that that amount may not represent what somebody's income has gone up. So there could be people, they're playing the child support game and they're looking at that and they're saying, well, my income's gone up 30%. So why would I provide my income information to the organization? There's very little we can do with that other than we can increase it by whatever amount we're allowed to at that time. That can get started for the recipient immediately then once, the statement of recalculation, all that process goes through. But that recipient still has the option of making an application to court and having a court then say, I think there's other income here, or we're going to impute income, or whatever needs to happen. The last thing we like to do is to always say to people, we have the option of applying to court, because we all know that's not so easy. But unfortunately, sometimes that is what it comes down to. We'll take it as far as we can. And then in certain circumstances, parties may be better off applying to court or having legal representation, that type of thing. So we mentioned the legislation. I won't go into any detail on that, but just so you know, we are part of the Family Law Act. And it is Section 154. So you can find us there if it so interests you. And then the regulations. And the regulations really sort of go to the heart of the program in terms of all the timelines and things like that Christian was referring to that we are bound by. There's other places where you can get information on what we do. The portal is a good place to start. It has some very basic information, and it has that questionnaire, which again is just to sort of help guide people to get an idea. Is this the program for me? But we don't want people to then, be unsure of their answers and just decide, oh, I don't meet the criteria. We really want them to contact us and, we can have that discussion with them. The portal will then link you to a BC government website that has much more detailed information on it. And there's a direct link there. It's where we're housing that. We have a general information fact sheet. We have some copies with us, but they're also uploaded into your materials. That's for your benefit, but you can also give that out to, anybody that you're assisting. Those are available. Stay tuned. We're now working on a pamphlet. Hopefully a pamphlet is not so outdated that by the time we get it out there, people say, what the heck is a pamphlet? Nobody's going in anywhere to pick one up. But, it's also a way just for us to get the information out to people like yourselves who are going to be helping those who could benefit from our service. So that's coming up. So that's basically the summary or the details you could say of our program. And we're happy to answer any questions that you have, or as I said, or even on any of our other programs, if there's something that you have a burning need to know.
Hi, I'm wondering if judges are being educated about this and if they're including them in orders.
Great question. One of the challenges that we had out of the Kelowna orders that we received was that, judges would often put things in an order and you could see the intent behind it. And it was, the intent to maybe assist us or help it move it forward. And it often backfired. And so we have informed the judges of the program. They've been very supportive. They were quite excited about the fact that it was rolling out. They looked at it as an opportunity that they were hoping they wouldn't be dealing with as many retroactive orders in the future. And we have provided them also, some terms that they can add to their pick list as to how to write things up, because again, that's often a stumbling block for us. We receive an order and, just because of the way it's written, we're not able to proceed. So we'll hopefully stay engaged with them on that as well over time.
I have a couple of questions. The first one is, when it comes to people applying for Child Support Recalculation Service, I don't know if you're the one looking at them, but what do you see tend to be the dynamic between the parties? Like, are they fairly cooperative, or is this, because I imagine, if they were cooperative, they wouldn't need to do this, but it seems like there is a fair amount of, for the income and that sort of thing that they might need to provide. I do know you have a grid for if they don't provide it, but still.
I think it's quite a range. So, just like I'm going to plug the Family Maintenance Enforcement Program, the BCFMA, because we partner with them. And, if you enroll in the program before there's conflict around this, then we can reduce the likelihood that conflict is going to happen. And it's also, at the bottom level, we just do the math for you. So they don't have to look up the guidelines. They don't have to figure that out. They can be getting along and saying, we'll enroll in the program. We don't have to deal with it. And a lot of people are uncomfortable sending their tax information to the other party who, they have some conflict with, right? Or just for privacy purposes, they don't want to do that. So there's definitely people, I think, who are paying their support. They're getting along. They've got a very cooperative arrangement. They're both engaged with the children and they find the program useful. And the same thing with the Family Maintenance Enforcement Program. They can be used as an accounting service for them. Then we also have parties where, as we indicated, there may be a safety concern. And we're reaching out to them and we're talking to them and we're giving them the details of, how we're going to be contacting the other party. Do they have a safety plan? Do they have supports? That type of thing. And they're really trying to minimize any communication with the other party at all. So I think it can work, for anybody as long as they meet the criteria.
Okay, thanks. Second question is, do you have an idea of whether this program is aiming to also be applicable to Supreme Court orders? And if so, when that might come into fruition?
Well, first part of your question is yes, we would like definitely for it to be applicable to Supreme Court orders. We find that's one of the largest reasons why we have to decline enrollment at the moment. And when is a question, unfortunately, I can't answer. And given by your smile, you probably understand why. So, we're reaching out, but these things can take a while. It took 14 years to expand it province-wide. We were one of the early provinces to have a pilot in this, and then we're one of the last provinces to enroll it province-wide. We're benefiting in some ways from that, in that, we're able to learn from the program that we had previously that came out as a pilot, and pilots tend to be pretty restrictive. And we're also able to benefit by learning out what some of the other provinces and territories, what have they done over the last year? So some of the criteria that we have opened up, we're sort of first out the gate on opening up, and we're seeing how that goes. And I'm really hopeful that we're going to see how it goes and we're going to be able to open up a little bit more. Age of majority, we're dipping our toe in, we're testing the waters, but we still require, agreement from the parties, and we'll see how that goes. And if that goes well, maybe we can open it up a little bit more. Supreme Court's a little trickier. However, with the Divorce Act changes, we can recalculate with Divorce Act orders once we have Supreme Court on board. So we'll get there for sure. Yeah.
Okay, thank you.
somebody over here.
Are you finding that more payers or more recipients are enrolling? And what has the uptake been like from the province in terms of enrollment?
Definitely finding more recipients are enrolling, you know, like it's not even close, right? And so I think payers maybe are not even maybe quite aware yet that they could enroll because their income has gone down. Right? That, you know, people just assume this is a way to increase child support, but it's not necessarily. That's not necessarily what happens, right? So we went from a program where we had Christian who managed the previous program as well as an entire other program, and he had one person doing recalculations. We now have 5 people doing recalculations, and you know, as everywhere else in the world, we're dealing with a little bit of staffing turnover. But they are getting busier, right? And so, you know, we wanted to do a little bit of a soft launch in order to make sure we had the kinks out of the system. The portal was brand new. So that was something that came with the expansion, and we wanted to make sure that was working well. And so now we're at the point where we're really trying to spread the word. And so more people can find out about it, make use of the service. So it's been a slow, but definitely like increase over time in terms of how many people are enrolling in the program. We're getting a lot of positive feedback, especially from victims where there's some family violence, that they're really have, you know, told us that they've been wanting to increase their child support. It wasn't worth the risk of going to court or dealing with it. And they're feeling that, you know, this program is enough sort of separation that they're enrolling in the program. So that's really satisfying for us to see too. When you roll something like this out, you don't always know, right?
I'll just keep the mic. In a case where an order is made when the payer isn't present, but there's an income, I guess it would be imputed. You know, would that be something where it would be appropriate to?
No, unfortunately, we're not able to recalculate on imputed income.
Okay.
And, you know, sometimes situations change though. So it may be that when they were first in court, it was imputed income. They then went back to court. So it's, you know, whatever happened in the most recent order, not whatever happened in the original one. It can also go the other way, where the parties were present, you know, if they were able to present their income. 2 years later, the payer now has some self-employment income as well, and we're not able to recalculate. So because we say no now, doesn't mean we're going to say no next year, but it can go both ways.
Thanks. So is that like 10% a year increase for the first couple of years and then 15%? Is it each year that it'll be bumped up, or how does that work exactly?
See if I can go back to that slide. So I never remember the numbers, Christian would, but so it's 10% if the last either recalculation or basically the last time child support was addressed. So is that from an order? Is it from an agreement, or is it from a previous recalculation? If it's been less than 2 years and the payer doesn't provide their income, then we have an increase of 10%. If it's been more than 2 years, but less than 5, it's 15. And you can see it moves up to 30%. I don't think what's the highest so far that we've had? And we've had 130 so far. That was probably a bit of a shocker for somebody, and it may motivate them then to provide their income. Now, these aren't meant to be punishments, right? These are meant to encourage people to provide their income. And that's, you know, whether it does or not, of course, we have no way of testing that out. But that's the idea. And it's not just payers, of course, because now that we're doing shared situations, you know, both parties are really payers when it comes down to it, although one might ultimately be paying the offset amount. So you may have a recipient who enrolls in the program who also has to provide their income information because that was taken into consideration at the time of the order. We will increase their income by 10% as well if they do not provide their information.
Was the pilot project, I thought it was like 10% per year with the pilot project. Is that right? Or
It was. The difference with the pilot was that it was mandatory enrollment. So as soon as a court order was made, it was enrolled in the program. And so then we weren't dealing with orders that were 3 or 4 years old that hadn't been addressed. It was just always 10%. A lot of pressure on people in the room to, carry the weight of all the people online. I don't know if there's any questions from anybody online yet. I guess, well, there's one more here, so I guess we'll check then in a minute. Okay.
Yeah, my question is this program also open to step parents who have support obligations?
No, because that's the in place of a parent, right? Someone standing in place of a parent. Got that right, Christian? Christian's my fact checker.
In the cases where in the second test for eligibility and under no, you had pattern of income. I'm just wondering if you can clarify what that means.
Sometimes when orders are made in court, typically, or even in agreements, they'll do an average of income, or there'll be, a pattern of income where, like in the movie industry or something like that, where somebody makes a significant amount of money for a period of time and then they don't make any money for 6 months, that type of thing. So if it can't be very clearly identified that this is an annual income, and an income could average out in a year, that's fine. Some people work seasonal work, right? But if it looks like there's something that could shift, so the income that they give us for last year may be so out of whack for what they're earning this year, then we can't do it. So we don't want a situation, again, where, somebody didn't earn any money last year, but they're going to earn a significant amount this year, but now they're not paying any child support. Or the opposite, right? Where their child support is based on an amount that they can't reasonably pay. So that requires some discretion. And basically, an administrative service removes discretion as much as possible. Okay, well, if there's no more questions, that's fine. We did bring a few of the fact sheets with us if anybody wants to take one with them. And again, you're free to give those out to anybody in the public who wants more information on it. The best place to send them is to the portal, and then they can go from there. They'll get linked up to even more information. And the fact sheets also in the online materials that you have. Okay, so thanks so much. Again, we're really excited about our program and really wanting to promote it and hope that people can really make good use of it. So thanks for coming today.